morning, this is the Kelso Report for Wednesday, December 21st, and I'm your host, Clark Kelso. Our featured case today is in the area of copyright law. The explosive growth in websites that permit uploading, storage, and downloading of information has been both a boon and a curse to authors and publishers. On the one hand, the internet has opened up huge new markets. On the other hand, the internet makes unauthorized copying of copyrighted materials only a click away. In UMG Recordings versus Shelter Capital Partners, the Ninth Circuit found against the publishers and authors and in favor of a publicly accessible website that enables users to share videos with other users. The evidence showed that while the owner of the site took substantial steps to remove any unauthorized copyrighted material from the site, and provided routine warnings to users not to upload copyrighted material without proper authorization, the site nevertheless contained unauthorized copies of some movies and music videos. The Safe Harbor provision, Section 512 of Title 17 of the United States Code, limits a service provider's liability for, quote, infringement of copyright by reason of the storage at the direction of the user of material that resides on a system or network controlled or operated by or for the service provider, close quote. Now, to qualify for this safe harbor provision of the Digital Millennium Act, the service provider must not have had actual knowledge of infringing material, must not have been aware of facts from which infringing activity was readily apparent, and must take action expeditiously to remove or disable access to infringing material when it is brought to the service provider's attention. In addition, the service provider must not receive a financial benefit directly attributable to the infringing activity. The primary argument on appeal in this case was whether the safe harbor applied only to a web service provider that did nothing more than provide web hosting services, in other words, provide storage, or whether it also applied to a web service provider that owned and operated a website that actively facilitated the sharing of movies and videos. Reviewing the history and language of the safe harbor provision, the Ninth Circuit concluded that the phrase, quote, by reason of, close quote, in Section 512C, should be given a broad interpretation that included a service provider whose website not only stored material for sharing, but actually facilitated storage and sharing. This is a huge win for web services that promote sharing of information, videos, music, pictures, text, and so on, through the internet. Now, the last time the Supreme Court took up this type of issue was almost 30 years ago in Sony Corp versus Universal City Studios, and the court in Sony reached a similar conclusion, that the producer of the technology that facilitated copying could not be held liable as a contributory infringer. My guess is that the Ninth Circuit has correctly interpreted the safe harbor provision of the Digital Millennium Act. But the Supreme Court just might take this case simply because of the tremendous importance of the issue to a large and growing segment of internet business. And now to our one-liners. Our first is in the area of civil procedure and good faith settlements. In Tiffin Motorhomes versus Cummins Inc., the 4th District held that co-defendants who manufactured different parts of a motorhome, one the engine, another the coach, and a third the chassis, and were being sued solely for breach of warranties and not for tort damages, were not, quote, co-obligors on a contract debt, close quote, under Section 877.6 of the Code of Civil Procedure, and were therefore not able to take advantage of Section 877's good faith settlement protections. In particular, one of the defendants settled for a relatively small sum and then sought an order from the court approving the settlement as a good faith settlement pursuant to 877. The trial court granted the motion, which gave that co-defendant protection from indemnity claims from the other co-defendants. However, the 4th District reversed, concluding that the warranties arose out of separate contracts, and under the terms of the statute, Section 877 did not apply. Next, in the area of evidence, in People versus Covarrubias, the 4th District held that the trial court erred in admitting testimony from an expert on Mexican drug organizations, who testified about the structure and practices of drug trafficking organizations. When the defendant, who was caught transporting across the border a large quantity of marijuana in a truck, had not been charged as a drug courier or a member of such an organization, and whose planned defense was that he was unaware there were any drugs in the truck. The 4th District held that the trial court should have excluded the testimony under Evidence Code Section 352, since there was no evidence at all connecting the defendant to such an organization. The testimony was otherwise irrelevant. Next, in the area of public records, in ACLU versus California Department of Corrections and Rehabilitation, the 1st District held that the trial court erred in permitting CDCR to withhold records containing the names of pharmaceutical companies from which the department tried to procure a prescription drug, sodium thiopental, for use in executions. The department made only vague claims that disclosure of the names of these companies would create security problems, and those vague claims were insufficient to justify withholding information that otherwise was presumptively public. The court also held that CDCR could not redact large amounts of information from documents that were otherwise producible under a blanket claim that the information was not responsive to the PRA request. The court remanded to the Superior Court for further proceedings. Next, in the area of commercial leases, in Fratelli versus 350 North Canyon Drive, the 2nd District upheld an exemption in a commercial lease for space in a shopping center that protected the lessor from any and all damage claims resulting from interference with the lessee's business during shopping center renovations. The court held that the exemption applied to claims for breach of the lease, breach of the covenant of quiet enjoyment, negligence, and rescission. The exemption would not protect the lessor from a claim of gross negligence, but there was insufficient evidence of gross negligence as a matter of law, so the 2nd District affirmed dismissal of the complaint. This was, of course, bad news for the plaintiff, whose business probably was actually ruined because a shopping center renovation project that was supposed to be quickly completed stretched into a 1-year project. The rent concessions offered by the lessor were simply not enough to offset the drop-off in business, and the lessee turns out to have been in the wrong place at the wrong time. That's it for today's Kelso Report. Have a great day in the law.